Morning. Bore-da. Hope you're on a good day so far. If you attended the stakeholder last year, you would have heard Welsh Government talking about appeal reform. As Tony said, that's now happened. I'm pressing the wrong button. Yeah. And the regulations came into force on the 5th of May 2017. Myself and Hefin have been heavily involved in getting the Inspectorate ready to deal with the changes required by the legislation and to ensure that the transition between the old and the new regulations was as smooth as possible, not just for us but for you as well. So some of you will have already dealt with appeals under the new regulations, and some of you won't have had the pleasure yet. Either way, we thought it was a very good idea now to talk you through the main changes and what is required of all of us. So I'll just hand you over to Hefin, who's going to go through some of the key points. There will be time for questions after.
Okay, bore da pawb. Unlike Mark, I'm not fortunate enough to have my own hair left. Okay, so as Joe just mentioned, the new appeal regulations recently come into force. They apply to applications made or notices served on or after the 5th of May 2017. So the key goal is to deliver more timely decisions on appeals by front-loading the appeal with all the essential supporting documents and involving an inspector at an earlier stage. So the changes are going to have a big impact on all involved in the appeals process. So the purpose of the presentation is to run through the key changes to help raise awareness and, as Joe just mentioned, to answer some of questions you have. So here's a comprehensive list of the case types the regulations apply to. You'd be glad to know it's on the guidance on your USBs, so you don't have to write them all down. Okay, they're mainly what we call our bread and butter day-to-day cases. And the one set of regulations, as opposed to regulations for each case, will hopefully make it a far more user-friendly system, and again, try and achieve the goal of delivering more timely decisions on appeals. So it'd probably be helpful at this stage if I ran through what we consider to be the main changes that affect appellants and local planning authorities, starting with the full statement of case. So the intention is for the appellant to submit the full statement of case with the appeal submission. Again, that's the whole intention of front-loading, so the inspector has all the information from day one. As a result of this removes the appellant's right to submit the statement at a later date. The statement cannot contain matters which would not be for the local authority unless it could be demonstrated they couldn't have been raised previously. And also, it's not for the inspector to determine what the statement of case consists of. So, for example, if it's brief, if it's too long, it's accepted as a full statement of case. As Tony mentioned previously, guidance on this matter can be found on the USB sticks. So, another key change in the local authority questionnaires. So, as you may be aware, local authorities currently have to submit questionnaires for householder and commercial appeals within 5 days of the starting date. That also applies to all the cases listed in the previous slide. I can imagine this is going to be a challenging task for local planning authorities, but hopefully we can work together to help the process work. For example, use of submitting questionnaire documents by links will hopefully make the matter somewhat simpler. Local authorities can also rely on the questionnaire to form their statement of case, with the exception of enforcement appeals, discontinuous notices, and called-in applications. So, the next change is the deadline for the submission of statements. As I mentioned previously, the appellant doesn't have an opportunity to submit a statement because that's all submitted with the appeal. As you'll be aware, for appeals proceeding by old regulations, the statements must be submitted within 6 weeks of the starting date. The new regulations change that deadline to 4 weeks. And that also applies to interested parties as well. There's also a new final comment deadline. Rather than the 9 weeks for existing old regulations, that's now changed to 6 weeks. And it is one other big change with final comments, in that third parties can now make final comments. I'm just going to pause to leave that sink in a second. Hopefully that'll make interested parties feel more involved in the appeals process. should point out the deadline for written statements of evidence for cases proceeding by inquiry remains 4 weeks before. So, another interesting change to procedures. Written representations is the default procedure where we expect the majority of our appeals to follow. But it's possible for an inspector to hold a topic-specific hearing or inquiry session. For those of you familiar with the Development National Significance process, we've recently done that for one of the applications. So it's for the inspector to decide what matters he or she considers would be beneficial to be discussed at a hearing or inquiry session, and only that matter can be discussed. So for example, if an inspector calls a hearing or inquiry on ecology, people cannot discuss highways, character appearance, what have you. The inspector also invites anyone he or she feels their presence would be beneficial, and only they are entitled to participate. However, there are open events and members of the public can attend on request to speak at the inspector's discretion. So, the procedure must be confirmed by week 6. If a hearing or inquiry is needed, the inspector must also issue a statement of matters which are to be discussed by this date. Okay, as you see there, we've also got new enforcement regulations, new fees regulations, and the main change is that the fee must be paid to the local authority before the timetable for the submission of evidence on the appeal can begin. To make this work, it's crucial the local authority specifies the fee in the enforcement notice explanatory note. It's also very important that the local authority advises us as soon as the fee has been paid, or if it hasn't been paid within the 14-day deadline. This will avoid any unnecessary delays starting the appeal timetable to help deliver the more timely decisions. Clearly, closer working relationship between the inspectorate and local authorities will help matters progress smoothly. So, there's also another interesting change for lawful development certificates. As some of you may be aware, there was no deadline for appealing against the refusal of a lawful development certificate. The amendment to the DMPO now introduces a 6-month deadline for appealing. Important to note there that it doesn't apply to non-determination appeals. So, this is a new interesting piece of work for the Inspectorate. Under Section 215 of the Town and Country Planning Act, the local authority can serve a maintenance of land notice requiring land, including buildings, to be cleaned up where the condition adversely affects the amenity of the area. I was going to use a photo there of Anfield, home of Liverpool Football Club. As an Evertonian, I feel quite strongly that place is an eyesore, and the council should do something immediately to resolve the matter. Because of copyright, we've opted for this one. So, any owner or occupier served with a notice can appeal under Section 217 of the Act. The appeals were previously dealt with by the magistrate courts and now be dealt with by the Inspectorate for notices made on or after the 5th of May 2017. They're treated the same as enforcement appeals, although there's no fee for making the appeal and no deemed application. I'm getting to the end of this, you'll be glad to know. Okay, so another change which most of you will be aware of, cost applications can now be made on all procedures for planning appeals. As a result, where the sole reason for a request for a hearing and inquiry was to make an application for costs, those appeals are now proceeding by the written representations procedure. It says their guidance is available on the Welsh Government website. Okay, in order to achieve the goal, which is to deliver more timely decisions, we've agreed short-term ministerial targets with Welsh Government. There they are there, and again, it's in the packs, I believe, so no need to write that down. So you'll be glad to know this is the end of my part of the presentation. I'll hand you over to Joe and say diolch yn fawr am wrando, and more importantly, enjoy your lunch.